the Senate Finance and Policy Education Committee will now come to order, and for the record, we have a quorum. Today, we have Senate File 2307 and Senator Mathews. This is a data privacy, and I might add for the record that we want to do this quickly because we want to be outside, okay? So I'll keep that in mind. All right, so Senator Mathews, first, I think, you want to, since this isn't your first committee, you want to talk about your bill quickly, and then we have an amendment.
Yes, Mr. Chair, I will, and I'll keep your timing advice in mind as well. Thank you. So members, we have Senate File 2307. A little history on where it's come so far is this is a bill to help with the technology that can be utilized in our schools with our students, and to put some privacy protection in place on our student data. I want to thank you, Mr. Chair, and the committee for hearing this after deadline. I want to thank my colleague, Senator Bigham, who is the initial chief author on this, did a fantastic job getting it through the Civil Law Committee before we switched authors. I also want to thank my House authors as well. We've been working closely to get this across the finish line. The bill, as it started, mainly had two topics that we're trying to address. One was some student and parent protections for their curriculum. The original version had opt-out clauses to allow parents the right to opt out if they had concerns over the way data was being used in curriculum. And the second part of the bill was about surveillance and putting some protections and guardrails around the ability to surveil student usage of electronic devices and so forth, particularly while outside of classroom hours. In working on this legislation, we've agreed to essentially drop and tone way down that first part, the opt-out provision of this bill. You gave a lot of guidance to that, Mr. Chair. Worked with many of the members and stakeholders on this. We are still specifically trying to get at some protections of the second piece of the bill, the surveillance piece. So the first section, and then this will be in the A9 amendment when we officially move that, but the opt-out's essentially being replaced with a notice provision to give parents the avenue to go when they need to raise concerns or questions, allow their voice to be heard on that, but the full-blown opt-out piece is no longer in the bill. And then the second section, that's that language is on page 3 of the A9 amendment. And then page 4 has, no, page 3 as well also has the technology and surveillance piece to it. So this has gone through a number of conversations, number of stakeholders that are here to share it. Technology advances faster than our ability to regulate it, and this is particularly true in our schools. The pandemic dramatically expanded the use of school-issued devices with surveillance capabilities, and new tools are able to scan volumes of our students' emails, chat messages, files, and work. We've worked really hard with the stakeholders over the history of this bill. This has evolved over many, many rounds of revisions, and this version is to ensure that schools are not unduly inhibited in their use of the software they rely on, but still have some protections in place for students and families. So that's kind of a brief history and overview of the bill, the path that it's taken. I believed we had enough of an agreement, worked on it behind the scenes all session. I believe we were close enough that I granted it a hearing in the Civil Law Committee on the final week before deadline. We had a very, very thorough and expansive discussion in the Civil Law Committee. And then since deadline, we've made a stop in rules, and now then greatly appreciate you granting a late hearing to this bill, Mr. Chair. So with that, I'm ready to answer any questions or ask the committee to move the A9 amendment or proceed how you would like.
Yeah, I don't mind the bill, but you bugged me hard enough, so not that it works all the time. So, yeah, we'll have Senator Uyghur move the A9 amendment. And you kind of went over the bill. Is there anything else we have to, did you want to summarize the A9 amendment or anything else in there?
I'll point out, Mr. Chair, thank you.
I know you had a couple of things you talked to me about that you changed. I just want to.
Just a couple of changes that came up recently. Page 2, line 24. Was a discussion with some of our technology companies. This is a change from previous versions of the bill that said 30 days. They raised concerns that requiring them to destroy data within 30 days could cause problems in certain cases that they laid out. I've decided to settle on 90 days. I believe you were in support of that number, Mr. Chair. Make sure that they had adequate time, especially if they're renewing the contract and that may lapse for a few days before a contract is renewed, not wanting them to force them to destroy data right before they re-up for another term with a school. So that was one recent change. Page 3 at the top, line 1 through 5 was another recent change to make sure that we weren't catching simply web-based cloud services into this rule about not using data for commercial purposes, because a cloud service essentially does not perform that function anyways, and wanted to make sure that nothing was read in a way that would negatively apply to them. They've essentially described themselves as the storage container that data is stored in, rather than being an actual technology provider. And then, let me make sure I find it here, Mr. Chair. Page 3, line 14 is the notice provision that replaces the opt-out, that section and following, provides giving notice, and then line 3.22 directing them to allow parents and students where to direct questions and concerns over it. And then subdivision 14 at the bottom of page 3 and into page 4 is the language on the monitoring piece of the amendment.
All right. Members, any questions on this? The thing I see is just, I mean, it's good, and thank you for making those fixes and working with the school orgs to tighten it up a bit. We don't want to put any undue burdens on the schools, but this is a lot better than what it was, and it still, I think, gets to the point that the child's information, because they're in school and using these devices, is the child's information, and not to be used commercially or exploited in any way commercially by anyone. It's protected, it's private, it's for a particular purpose and not for making profit or anything else. So good, it's really a good idea. So with that, members, we are going to adopt the A9 amendment. All in favor of the A9 amendment, say aye. Aye. Opposed? Okay. That was kind of weak, but I think it was there. So we have a couple testifiers. We have Mr. Anthony Padronos. Anthony, are you here? Okay. Welcome to the committee. Please state your name and who you're with for the record.
Good afternoon, Chair Chamberlain and committee. I'm Anthony Paternus, the Executive Director of Technology for Osseo Area Schools. I'm here today as a former teacher, current district administrator, and parent of school-aged children to speak on behalf of Osseo Area Schools, the Minnesota Association of School Administrators, and the Minnesota K-12 Technology Leaders regarding this bill. Technology is inevitable in our society, including schools. It creates conditions in education to innovate and have efficiencies in operation and instruction to invest more time on our scholars' learning as they need it. We also must prioritize information security and privacy while balancing instructional and operational needs. This bill, as currently amended, moves this direction by holding technology companies accountable and to high standards with data and privacy while providing education professionals with the ability to use technology to meet learning needs. As school leaders, we share a common interest in digital security and privacy, and we have been working diligently for years to increase these protections for scholars, families, and staff when it comes to district-issued technology and technology systems. This is a priority that keeps many of us up at night. This bill, with the current amendments as proposed by Senator Mathews, provides a statewide structure to strengthen the work many school technology leaders across Minnesota have been independently engaging in through technology vendor contract negotiations to ensure security and privacy protections of our scholars in digital spaces. As public schools, we have the charge of delivering high-quality instruction to develop scholars in Minnesota to be successful and productive members of our communities. Instructional delivery has changed over the years, and technology has been foundational to create effective methods of adaptations to meet the individualized needs of our scholars. For example, many school districts have moved away from traditional textbooks to digital instructional resources that are adaptive to different scholars' learning needs and provide anytime, anywhere access to learning. I want to thank Senator Mathews and others for their engagement and collaboration with concerns we've had with this bill in order to ensure schools can deliver on our charge in education and meet our common interest of greater digital security and privacy protections in the increasingly digital landscape of education. We look forward to continued partnership as this bill moves through the process and any additional language changes that may be presented. Our interest continues to be that education professionals are able to effectively use digital tools that enriches, enhances, and produces high-quality learning experiences for our scholars, ensures effective operations of schools, ensures the ability to meet state and federal laws, ensures cybersecurity, and ensures the safety of our scholars with district-provided technology and technology systems. Education professionals have a different need and interest in digital data than technology companies who develop the products and services we utilize. Thank you, Chair Chamberlain and committee, for your time this afternoon.
Thank you, Mr. Paternus. So just to make sure this is workable. Oh, Mr., you got to come back. I know I wanted to be quick, but so just to confirm, the changes are workable for the technology departments in the schools.
Yes, the current language as amended and proposed is workable for our functions as educators and the technology professionals to help ensure that the systems work. Our greatest challenge and concern that we had and worked with many stakeholders on this was really around that opt-out language. We have core systems that are essential for the delivery of instruction as well as operations in terms of managing grades and systems and schedules and transportation and so forth. And so those concerns have been addressed as we look at the current language as proposed.
And thank you. And at the same time, making completely clear to the vendors and others that student data is to be protected and secured. Okay. Well, thank you very much, Mr. Paternus. Appreciate it.
Thank you.
Next up, Ms. Caitlin Snyder. And then Mr. Liddell, he's online, I believe. A remote, I should say. Welcome. Please state your name and you know how to go about this.
Good afternoon, Mr. Chair and members. My name is Caitlin Snyder with Education Minnesota. We represent over 86,000 educators across every school district, including 463 local unions across the state. Education Minnesota supports Senate File 2307. We share concerns about off-campus monitoring of student conduct, and the gendered and racial dimensions that may unintentionally take. We would not support legislation that will make it harder for educators to do their jobs. In Minnesota, school is not optional, and fortunately, most students attend public schools. Among the responsibilities that schools and educators have is to respect and protect the privacy of students and their families. This bill requires that the technology vendors who receive our students' data in the course of providing school information services and curriculum abide by the same rules that schools do. This bill limits tracking of students by tech vendors, makes sure student data remains private, and prohibits the sale of student information. It would also require districts inform families about their students' privacy rights. This bill protects students from unwarranted surveillance. We have come a long way from students periodically visiting a computer lab. Students are often sent home with laptops, tablets, or obligations to communicate electronically on their own devices. When the devices they carry are school-issued devices, they are often equipped with all manner of monitoring software, such that individual words that students use can generate a flag for someone to review. While the proponents of this surveillance assert that it is necessary to prevent bullying or help with mental health needs, it can also be a superhighway for racially biased behavior referrals and intrusions into students' personal discussions about their identities. There is research showing that schools with a higher number of students of color are more likely to have a range of security measures. That is, in a word, troubling. Worse yet, researchers have found that relying on surveillance contributes to racial inequities in school discipline, academic achievement, high school graduation rate, and involvement in the criminal justice system. Lastly, this bill will not necessitate greater work for educators. It is the responsibility of every adult in a school, curriculum instructors, tech directors, superintendents, principals, teachers, and education support professionals to provide for the learning of our students. Educators and administrators will jointly collaborate to meet the requirements of this bill. For these reasons and more, we are happy to support Senate File 2307. Thank you for your time.
Thank you, Ms. Snyder. I did have, you can answer this question if you want. Maybe Mr. Paternus could come back too, but is it your opinion as well that the other concern we had was trying to balance this is that schools are also obligated to protect, you mentioned bullying, protect students from unwanted harassment, or we'll just talk about health and safety of the kids. So being on these devices and having access to the internet, a lot of bad stuff floats around out there, gets sent back and forth for whatever reason between students or coming from the outside in. So is it your opinion that the way this is written, that balances the need for privacy against that need for protection for the health and safety of the kids and the obligations of the school? Does that make sense? Or should I have Mr. Paternus?
Thank you, Senator Chamberlain. My only hesitation in answering is that I saw the amendment just before committee. I've talked with our attorney about it. So the underlining bill language, we think absolutely protected the privacy concerns while also being able to implement requirements under state and federal law. So assuming that language was maintained, which I'm sure it was, yes.
Okay, thank you, Ms. Snyder. Mr. Paternus, would you mind coming back up and answering that question quick? So I'll kind of go over it again. So in your opinion, this has to do with health and safety, and that was one of our thoughts here too. So in your opinion, you had already mentioned a balanced issue before as far as providing services. Does this offer the right balance to be able to protect the health and safety of students in accordance with state, federal laws? And, you know, we still have to monitor, and the school still has to monitor and track to an extent. It's still school property and school wires and systems. So to help balance, and you're still able to provide for the health and safety of the kids and protect them from stuff.
Yes, as we've reviewed the language, as the monitoring language has changed, that was another area of concern that we had brought up very early on. There was additions brought in very early around allowing districts and district personnel to be able to continue monitoring to meet state law, federal law, and E-rate funding programs, which also requires us to follow the Child Internet Protection Act.
Sure.
So that would include our authority to continue to monitor for the Minnesota Bullying Act and other legislation around that, and safe and supportive schools, as well as the federal laws around child internet protection. So the way that we are reading this and interpreting this language now, it is allowing our authority to still be able to maintain that from district employees and district personnel, while it does give tighter requirements to vendors on what they can and can't access from a monitoring situation.
Thank you very much. Appreciate that. And we have Senator Mathews, did you have a comment?
Just to that point, Mr. Chair, I turn the committee's attention to page 4, where some of these items are listed out that you're discussing. A list of when surveillance can be allowed. Some of them I'll highlight are some of the things you mentioned. Line 4.15, activities necessary to respond to an imminent threat to life or safety. Number 5 on 17 and 18, comply with federal or state law. Number 6 below it is the E-rate program. Some of these are spelled out. That was our intention, and so far I believe that we've struck that balance with all the stakeholders.
Thank you very much, Senator Mathews. So, Andrew Liddell, you're online, remote. Welcome to the committee. Please state your name for the record. You may begin.
Thank you, Mr. Chair. Good afternoon, Chair Chamberlain and Senators. My name is Andrew Liddell, and I'm a technology lawyer and digital rights activist from Austin, Texas, where I live with my wife and 2 young kids. Today's actually my daughter's 7th birthday, so I'm in just as much of a hurry to get out of here as you all are. From 2018 through early 21, I co-founded and ran a privacy and health-focused education technology startup. And I also co-founded the Student Data Privacy Project, which is a grassroots parent effort to understand what information is being collected about our kids by tech vendors at school and what's being done with it. So I speak from experience when I say that today's digital products, including those used in school, collect a staggering amount of information about their users. And that information is usually used against those users for someone else's benefit. And that's by design. For 20 years, early stage investors have embraced both the surveillance business model and the move fast and break things approach to all things digital. New companies are incentivized to collect as much information as they can, use that information however they please to make as much money as they can, and externalize the costs to the user. Education technology vendors are often no exception. The information collected through school platforms includes demographic information, including information about age, sex, race, sexual orientation, and religious affiliation. It includes grades for every assignment, and attendance and disciplinary records going back to kindergarten. It includes every search, every website you visit, and every person you interact with. It also includes every mouse movement, how long you linger on an image or a test question. Truly, every single thing you do on a computer, all of this information is fed into an algorithm that is used to build a digital model of you. And this digital you not only determines what you experience in the digital world, but also what opportunities you have in the real world. Some applications are even able to monitor students' activities in real time or in virtually real time through their school-issued devices, even while students are not at school. Sometimes this is the purpose of the application. Much more often, it's because applications are built quickly, are poorly vetted, and are embedded with other companies' software designed to collect personal information for marketing purposes and transmit that information to data brokers who sell it on the open market. A May 2021 report by digital researchers at the Me2B Alliance showed that as many as 2/3 of applications used in K-12 schools leak student information in this way. Everything a child does on a computer for the 13 years they're in school is subject to being collected in this way. This vast trove presents risks for hackers. Digital profiles of children are sold on the dark web and are especially valuable because they enable criminals to open up credit cards and bank accounts in the child's name as soon as they turn 18. School districts and education technology companies are known to have some of the weakest cybersecurity defenses. So we have a situation where the most valuable information is in the possession of those least able to keep it safe. Cybercrime notwithstanding, I'm most concerned about how the currently legal uses of this information are shaping this generation of young people. These digital models of our kids are used in life-altering ways, including to determine which students will be recruited by a selective college and which will be referred to the local police. Currently, there are no practical limits on how this information is used, and no assurances that this information is accurate before it is disclosed to those who make life-changing decisions about our kids' futures. Other uses are concerning as well. Just yesterday, Vice reported that in 2021, a federal agency bought location data from a data broker called SafeGraph, representing tens of millions of devices and certainly including the data of children collected through school-issued devices belonging to visitors to K-12 schools and churches as part of a plan to enforce curfews during the pandemic. Even those of us highly sympathetic to the need to protect vulnerable people during the pandemic should stop short when a federal agency decides on its own that it can surveil U.S. citizens for whatever purposes it sees fit without oversight or disclosure. This current paradigm places kids at substantial risk and denies them both a childhood and a future. For all of us who came of age before the internet, childhood and young adulthood was a time of becoming. You made mistakes, you said hurtful things, but then hopefully you learned from them and grew into a better person. Now, everything you do on a computer from kindergarten through graduation is kept potentially forever to develop a digital version of you that may bear little resemblance to the person you actually are or want to become, and to be used against you by insurance companies, healthcare companies, and institutions of higher education. I'm not being paid to be here today. I'm here because today's polluted digital ecosystem is hurting my kids, their friends, and everyone in their generation in material and lasting ways, and I want to help clean it up. Others, representing IT professionals and school administrators, have testified against this bill, although I'm pleased to see they've come around, about how useful they find today's technology and about how hard it would be to make substantive change. But perceived efficacy and convenience to the administrative stakeholders should not be the only considerations. DDT was great at killing mosquitoes, but it also killed a great number of children, so it was taken off the market. Asbestos is an excellent insulator against those cold Minnesota winters, but it gives people cancer, so we don't use it in new school buildings, and we remediate old ones. Lead paint withstands scratches and scuffs better than other formulations, but kids like to eat it, and it gave them brain damage, so you can't buy lead paint anymore. Pesticides, insulation, and paint still exist, of course, just without the harmful additives proven to hurt children. In the digital context, the harmful additive is surveillance. Parents should have the right to determine whether to expose their kids to applications that surveil them constantly, and to not have that decision forced upon them by the government in the form of a school district that may be putting its own needs first and pushing the costs off onto children and their families. The consensus among cybersecurity researchers is that in the current digital environment, there is no such thing as de-identified data. Given enough data points, anyone can be identified. And right now, hundreds of thousands of data points are being collected on our children over their time in public school. It's possible that in the current environment, there are no actual alternatives to the surveillance status quo, but if you legislate it, and if you mandate change, the market will provide those alternatives, just as it did with pesticides, paint, and insulation all those years ago. I think that SF 2307 is a good start toward creating a healthier digital ecosystem for the school children of Minnesota, and I hope that someday Texas follows its example. By legislating that student data is not the property of technology vendors, and by limiting how that data can be used, and by sharply curtailing the surveillance of students, this bill safeguards the freedom and self-determination of the children of your state, and I urge you to support it. Thank you.
Thank you. Well, that was concerning, if not a little frightening, to be reminded of why we're doing these things and addressing these issues. Thank you, Mr. Liddell. I'm going to ask Ms. Gilbert, did you have a thought you wanted to share?
Mr. Chairman, thank you. Just a thought, and I will be very brief as well. And I'm Mary Gilbert Doherty from the St. Paul Public Schools, and I wanted to thank Senator Mathews because I did have a chance to talk. I know we're not supposed to mention the other body over here, but the chief author on the House side as well before, and talk to Senator Mathews about potentially just doing a little bit of tweaking, which we discussed, which we can work on, lines 4.8 through 4.11.
4.8 to 4.11. We're turning there now. Hang on.
As you know, St. Paul Public Schools has had a one-on-one device for over 13 years. And we were actually well poised for our community when the pandemic hit and we had to go to virtual learning. And as a result, I mean, I just want to assure you, like Mr. Paternus, that we do have very tight contracts related to privacy And the provisions that are included in this bill are currently included in our contract, as well as we do training for our staff and our students around digital citizenship on how to use the device in ways that won't result in bullying or any other intended consequences. The clarification or tweaking that I talked to Senator Mathews about, right now, obviously, teachers working in our virtual school or any of our staff that are working with students that may be in quarantine right now and may be getting their services virtually, the language on those lines limits it to just district employees or technical employees. And then depending on how different attorneys read it different ways, imagine that. It does include vendor, and which we were very happy to see because this was also included in the House amendment. But we wanted to just make it clear that that's everybody's understanding that, for example, this committee has appropriated money for Sena Foundation to provide fellows who provide individual instruction in our district or reading and math corps. And you've also appropriated money for like the St. Paul Promise neighborhood, where we have folks that are doing individual instruction directly with our students, and they're using the iPad, and they are accessing the information through the iPad.
So, Ms. Gilbert, I'm gonna try to cut to the chase
Okay.
here. So boil it down to 3 sentences. What's your challenge here?
Mr. Chairman, we would like to just make it clear that vendor in the language would include them, and make it clear that this language wouldn't exclude them, because in this case, they are not district employees.
So,
that would be
you're talking about, when you spoke to me, you talked about third parties outside the school who are not employees of the school, who sometimes have to have access to this technology that has this data, correct?
Correct, but it would only be for non-commercial instructional use.
So wouldn't vendor fit into that? So you mentioned Santa or someone else. They could be non-district employees that have access to the school systems for particular reasons under a contract or whatever the case is, and that they can have access to that information. Would vendor not cover that, though? I mean, like Santa Foundation or something?
Mr. Chairman, it absolutely would. The question that our attorney raised was that because it says or exam proctoring by staff contracted by a district or vendor, that the vendor would only apply to testing proctoring.
Oh, okay, I see.
So we prefer, so I read it exactly like you did and the way Senator Mathews did, but like I said, some attorneys said that because of the or there, that the vendor only applies to
Okay.
monitoring, and that would be one of the clarifications that we.
Okay, I get it now. Senator Mathews, do you have a thought? Otherwise, we can go somewhere else.
Mr. Chair, that was a suggestion briefly mentioned right before, perhaps just deleting that word "or" then makes everything a more clear listed area that vendors would then hopefully fall very neatly into that list. So I'm open to that change.
So if we remove the word "or," so it would read technical support by district employees or exam proctoring by staff contracted by the district, a vendor, the Department of Education, and notices provided in advance. Yeah, which or are you speaking of, the one after vendor?
Mr. Chairman, the one after district employees.
Okay. So I'll read that again and see if that makes any sense. So paragraph B, blah, 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 can engage in the activities, only engage in activities prohibited in paragraph A if activity is limited to a non-commercial educational purpose for instruction by district employees, comma, technical support staff by district employees, comma, exam proctoring by staff contracted by a district, a vendor, or Department of Education. Does that make it work? Should have asked the expert over here, Anne Marie. Does that make sense, Ms. Marie, what we're trying to do? They're trying to clarify that vendors are not, third parties like Santa would not be excluded, that they could be part of this.
Yeah, Mr. Chair and members, on line 4.9, I think the amendment would only need to strike or delete the "or" on that line. You can keep the other "or" at the end on 4.10.
Okay. All right. Great, thank you.
And Mr. Chairman, one other really brief
Yeah.
issue would be a student teacher that might be working all year with our staff also is kind of a weird character. They're not exactly district employees, and they're not exactly vendors either. So if we would include a student teacher that's under the supervision of the district or the school, that would help clarify that as well.
So what you're suggesting, Ms. Gilbert, is we would have to add student teacher in this language, right?
Mr. Chairman, correct. And I've spoken with Senator Mathews about that as well.
Is that okay with you, Senator Mathews?
Mr. Chair, yes.
Okay, so where would we, Miss Anne Marie Lewis?
Mr. Chair and members, to add a student teacher, I would suggest, let's see, perhaps on 4.9, and this will go along with the previous amendment discussed. On 4.9, delete "or" and insert student teachers, comma, and that would be the end of.
Okay, yeah, okay, that makes sense. Thank you, Ms. Lewis. Okay, so here's, I should have had you, you got it? Okay, here's what we're going to propose for an oral amendment. Starting on line 4.9, district employees, comma, technical support by district employees, comma, strike "or," insert student teachers, comma. Then we go on with exam proctoring by staff. Does that make sense, everybody? Okay, good. So I'll make that, are you okay with it, Senator Mathews?
Mr. Chair, yes.
Okay. All right, so that's what we're going to do. Everybody understand it? That's the oral amendment to this amendment. All in favor, say aye. Aye.
Aye.
Aye.
All opposed? All right, good. So we got that. So, thank you, Ms. Gilbert. Thank you, Judy. All right, those are all the testifiers. Members, any questions? Senator Uyghur?
Yes, Mr. Chairman, just to re-echo the appreciation for Senator Mathews, Bigham, and all the others that have worked so hard on this. One quick question perhaps, though, on the Section 4, Subdivision 15, there's an exemption for post-secondary institutions. I'm wondering, because we have students getting college credits in high school, whether it's college in the schools at the University of Minnesota, where they're actually at their high school or some other type program, is this exemption potentially a loophole?
Post-secondary institution exempt from 13 to 14, this exemption extends. Senator Mathews, any comment on that?
Mr. Chair, Senator Uyghur, could you point me to the line again?
Mr. Chair, page 5, I'm on the amendment, and line 5, the application of post-secondary institution, and there's an exemption. And at 5.4, it refers to an exemption for post-secondary institutions.
So your question, Senator Uyghur, is that a potential loophole? Because it's an exempt, a post-secondary institution is exempt from subject 1314, since a technology provided for purpose of a contract with, so does that make sense, Senator Mathews?
Mr. Chair, I'm going to ask Ms. Julia Decker to come up and try to help answer Senator Uyghur's question.
This is Ms. Who?
Mr. Chair, Julia Decker, Policy Director for the ACLU of Minnesota.
All right, okay, thank you, welcome.
Mr. Chair, Senator, that the intention there is that it simply doesn't apply to any device or technology contract in between a post-secondary institution or a device that's issued by a post-secondary institution. So if we're talking about if a student is using a device that's issued by a non-post-secondary public institution, then it is covered by this bill. If it is a contract between a public school and a technology provider, and the school is not a post-secondary institution, then they are covered by this bill. But if we're talking about contracts between a post-secondary institution and a technology provider, that's not covered by this bill. If it's a device issued to a student by a post-secondary institution, it's not covered by this bill.
Senator Uyghur?
Mr. Chair, I want to think a little bit more about it. You want to protect, the students. We're focused on the up to 12th grade, I imagine, but we have students that are enrolled in college, getting credits, and just the exemption for post-secondary institutions caught my curiosity, where you could have 10th graders, 11th graders, 12th graders. So let's pursue it offline, and there'll be other opportunities to address.
Thank you, Senator Uyghur. I would agree with you. I mean, I get it. So U of M, if they're doing PSEO or something through U of M, they're there. U of M gives them the device. U of M, this does not apply to that institution. So it could possibly be in a limited way. Senator Uyghur?
Mr. Chair, and Senator Mathews or Ms. Decker, do you know how many other states have similar laws in place,
Senator
like what is
Mathews?
being proposed here?
Who wants that one?
Mr. Chair, Senator Uyghur, this would be at the sort of vanguard, the front of some of the most protective student data privacy laws. There are other student data privacy laws in other states, but we feel this would be one of the most protective.
Excellent.
Final question.
Yes, Senator Uyghur.
And I do support the bill. I believe the civil penalties are in 1308, criminal in 1309, so that's, the civil would be 1,000 per violation up to 15,000, I believe. Criminal, I believe, is misdemeanor. Talk more about that, perhaps?
Senator Mathews?
Mr. Chair and Senator Uyghur, yes, and you're catching me trying to recall off recollection, but that is what would be provided under the Data Practices Act in the state of Minnesota. So it would, whatever the penalties are provided for, just generally under data practices, would be directly applied here. I'm blanking on exactly what the amount is for each lane of offense, but they would essentially match with the rest of the data privacy chapter.
All right, that's
Thank
good.
you.
Thank you. Well, that makes sense. All right. That's quite enough on this. Thank you, Ms. Decker. Appreciate it. So I'll just go ahead. You any closing comments, Senator?
Mr. Chair, thank you for this hearing. We're essentially trying to get at protection against surveillance and tracking, and the way I've approached this bill since working with Senator Bigham on it, and then since taking it over, is kind of under the general philosophy that we're all having to address in many areas of life right now with technology. Is just because you can doesn't mean you should. And I'm trying to thread that needle of how we make these laws and draw that line in this area. So I appreciate your time, Mr. Chair.
Thank you, Senator Mathews. I was just reading too, came across a thing, and some people might be familiar with, is they're starting to talk about too much technology in the classroom, that it actually inhibits, in cases, you know, good learning and experiences and growth, and that some educators I've read prefer, you know, getting them away from all those devices, and the best times they have is if they're able to sit outside and study and do their work, and then they're not paying attention to their devices, hopefully as much, or using other electronics. I mean, still have their phones, which is a problem, but just technology is a tool to educate. It can be useful, it can be helpful, but people are starting to rethink how much of that we need to use and how much is too much, to your point. So I thank you for doing this and getting it right. I think it's a great idea, and if we're in the vanguard of this, it's a great thing. I'm glad you could work it out with the schools and others. So members, we're going to be voting on this. Everybody else ready to do that? All those colleagues of mine, if you're at home and you can, turn on your screen so I can get or your audio. Yeah. So the motion is going to be to approve Senate File 2307 as amended, recommended pass, and send it to general orders. All right? All in favor of that, say aye. 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 Opposed? Great, unanimous. Thank you, Senator Mathews, and thank you, members, and all the testifiers for joining us for one late hearing. So with that, we are adjourned. Thank you very much.
Thank you, Mr. Chair and members.